Hi, this is Bridget Friedman at Friedman Law. I'm just here to talk about what does an estate plan consist of. So a lot of people say, "Oh, I need to do some estate planning," and the first thing they ask for is a will. And so a lot of people think that an estate plan or doing estate planning only involves the preparation of a last will and testament. So let me explain here a little bit what a real estate plan might look like for somebody who actually needs a complete estate plan. So the first document is the last will and testament. And it is in red because the last will only applies after you die. So you don't take the last will and testament and send it to the courthouse until the person has passed away. And once they've passed away, that is your cue to send the will down to the courthouse for safekeeping. That's not to be confused with probate. You send it down to the courthouse, they hold it, and then perhaps you're going to open probate, perhaps not. So the second document that would comprise an estate plan is the power of attorney. The third is a living will. And lastly, we have a healthcare surrogate. And the reason these three are in green is because all of those documents apply while you're still alive. So once you die, if you have a power of attorney, it no longer exists. You can't use someone's power of attorney if they have passed away. The healthcare surrogate is the same. You can no longer use their healthcare surrogate after they've passed. So what's the difference between all of these documents? Well, the power of attorney is the document that authorizes someone to make financial decisions for you. In Florida, they become effective immediately as soon as you sign it, and it is not terminated until you either terminate it or you die. The other thing about powers of attorney is that they survive through your incapacity. So they become effective as soon as you sign it. And then if you do become incapacitated with dementia or perhaps a coma or something like that, they still survive your incapacity. So someone can still use your power of attorney even when you become incapacitated. The other document that we have here is called the healthcare surrogate. The healthcare surrogate allows your authorized representative to make medical decisions for you in the event that you no longer can make those medical decisions. It also authorizes someone to have access to your medical records. So there is a HIPAA release embedded in the healthcare surrogate that we prepare usually, and that authorizes someone to request your medical records. Perhaps you need to go to another service provider, and if so, they can get your medical records from one doctor and bring them to another. And the last document is the living will. And the living will is a document that you execute. It's simply a statement that you're making while you're alive to say that if you are in an end stage condition, if you are in a terminal condition, or if you're in a persistent vegetative state, you are asking someone to take you off of life support if two doctors both agree that you have no reasonable probability, okay, of living without artificial means. So two doctors have to agree. One is your attending physician, and the other is a physician that is not your physician, that is an independent doctor. So that's what we talk about when we refer to estate plans. There's one other document not on this chart that might be incorporated, and that's a trust. So that's a discussion for another time, but sometimes people need trusts, and if so, that would be an addition to these four documents here.